Yes, Mr. McConaughey.
My Lord, you will hopefully have received what actually was the application to be added as an intervener in the EAT. That application was granted. It was on the basis of the document that you have been sent, but it was granted.
Yes.
And that document was the document that appeared before the EAT.
And it was just written submissions, and
Indeed.
Ms. Apps didn't show up
Yes.
in the end.
Yes. Indeed.
Right. Thank you.
I don't propose to make submissions on the submissions, but there is just one thing, which is that the references to Article 137, the withdrawal agreement. It should have been Article 127. I think it was just a slip. It's Article 127, which I'm going to take the court to
Yes.
now.
Right.
Or at least Article 4 first of the withdrawal agreement, which appears, the text of the withdrawal agreement that you've got in your Laurie's bundle is tab 17, page 331. I don't propose to deal with the preamble, but Article 4 is at page 333. And Article 4 of the withdrawal agreement provides that at 1, provisions of this agreement, the provisions of union law made applicable by this agreement shall produce in respect of and in the United Kingdom the same legal effects as those which they produce within the Union and its member states. That seems clear enough. Paragraph 2, the United Kingdom shall ensure compliance with paragraph 1, including as regards the required powers of its judicial and administrative authorities to disapply inconsistent or incompatible domestic provisions through domestic primary legislation. And paragraph 3, provisions of this agreement referring to union law or to concepts or provisions thereof shall be interpreted and applied in accordance with the methods and general principles of union law. Moving on to Article 126, which is the next page. Article 126, which defines the transition period as being between the date of entry into force, which is stated in the, at least in this version, to be 1st of February 2020, and 31st of December 2020. Now, in this case, the CAC, of course, never actually made determinations on the facts about when things happened and when they should have happened, but the complaint, as has been noted, related, at least in substantial part, to events occurring during 2020, therefore within the transition period. And Article 127 on page 335. Unless otherwise provided in this agreement, union law shall be applicable to and in the United Kingdom during the transition period. And it goes on to define a number of exceptions which aren't relevant for purposes today. Paragraph 3, during the transition period, the union law applicable pursuant to paragraph 1 shall produce in respect of and in the United Kingdom the same legal effects as those which it produces within the Union and its member states, and shall be interpreted and applied in accordance with the same methods and general principles as those applicable within the Union. I don't need to go through the rest of the article for my purposes. But what is clear, my lords, is that what we have is an agreement that, in respect of happenings during the transition period, it's clearly applied union law to those events. Now, the question is, of course, in our particular case, what happens if a complaint about events during that transitional period arises after the end of the transition period, because the complaint to the CAC was not made until March of 2021. To find the answer to that question, we go back to the Withdrawal Act, European Union Withdrawal Act, which appears at tab 18 in your bundle. Page 337 is the front page of the sections copied, and it's section 7A. That really bites here. Page 244, section 7A1, subsection 2 applies to all such rights, powers, liabilities, obligations, restrictions from time to time created or arising by or under the withdrawal agreement, and all such remedies and procedures from time to time provided by, for by or under the withdrawal agreement, as in accordance with the withdrawal agreement, are without further enactment to be given legal effect or used in the United Kingdom. And then the rights, powers, liabilities, obligations, restrictions, remedies and procedures concerned are to be recognised and available in domestic law and enforced, allowed and followed accordingly. Now, my submission is that that statement, that the rights and obligations are to be enforced, allowed and followed accordingly, requires the court to provide for a remedy in respect of acts pursuant to union law which require a remedy under the relevant domestic or EU-derived provisions. So, in the present case, where what we have is allegations of failures occurring during the transition period, it doesn't help EasyJet to say, well, you didn't raise your complaint until after the transition period. A remedy has to be provided for those failures, if they were, even after the transition period finishes, because the UK is bound to provide for such remedy under the Withdrawal Act and under the agreement. To make the point more solid, and it already is in my submission, one can look at section 7C, and that's page 346. Interpretation of relevant separation agreement law. Separation agreement law is defined at subsection 3 to mean any one of the following provisions or anything which is domestic law by virtue of any of them, and you see 7A listed there. And then at subsection 1, any question as to the validity, meaning or effect of any relevant separation agreement law is to be decided so far as they are applicable in accordance with the withdrawal agreement, etc. For our purposes, it's just the withdrawal agreement that is relevant. And then subsection 2, see among other things, Article 4 of the withdrawal agreement, methods and principles related to the effect, the implementation and the application of the agreement. So, the submission for the EWC is that it would be fundamentally inconsistent with the scheme of the directive, Article 11 requiring remedies to be available for breaches of the requirements enshrined in domestic law, for there not to be a remedy for events occurring during the transition period. And so any interpretation of the amendments to the TICER that seems to preclude such a remedy because of the gateway test being applied by EasyJet on their interpretation to Regulations 2021 has to be avoided. And so it comes to this, my lords. What we have is a set of amendments to the 1999 regulations, which, in my submission, can be construed so as to allow for the continued operation of existing EWCs created on the basis that central management is located in the UK. Practical difficulties that inevitably, on either side's case, are going to arise with exactly how an EWC can continue to operate arise on whichever construction one thinks is correct. So they, in that sense, in my submission, they don't help EasyJet with their case because difficulties arise anyway. Difficulties would arise in respect of deemed UK central management-based EWCs. So it's not difficulties which is the real nub of the issue. The linguistic indications are perfectly compatible on EWC's case with the idea that central management actually in the UK can continue to operate its EWC. The context of the amending regs, of the explanatory memorandum, and of some indications within the regulations themselves leads to the same conclusion that UK central management-based EWCs, not merely by virtue of being deemed to be so, but also by virtue of actually of being so, can continue to operate. And to add to all of that, the obligations under the withdrawal agreement and withdrawal act require courts to interpret the regulations so as to allow for a remedy for events occurring as they did here within the transition period. And that, in my submission, takes the court to a place where, cumulatively, it becomes extraordinarily difficult to say, if not impossible, to say the EAT was wrong, the CAC was wrong. Those decisions were correct, and in my submission should be upheld. Unless there are other questions for me, my lords, those are my submissions.
Is it right, strictly speaking, this is an appeal against the EAT upholding a decision of the CAC that it had jurisdiction to consider the complaint lodged in March 2021, you say, either entirely or very largely in respect of things done during 2020. You would say that even if the continuing jurisdiction if the continuing existence of the EWC were in question, I suppose you would say that at the very least the CAC had jurisdiction because of the timing.
I would.
Do we have to decide whether, if another complaint were submitted next week, as it were, in respect of continuing failure to hold meetings and so forth, whether that would succeed?
Does your lordship mean in respect of events occurring after? Yes.
Yes.
Yeah. Well, I suppose the effect of the appeal is that the reason the EAT and EWC's construction is wrong is that UK central management-based EWCs are taken out of scope entirely.
Yes.
And so the court would have to decide that that was wrong as a matter of construction.
Yes.
And if the court were to decide that, it would leave us in the position where the only correct or the correct reading of the amended regulations was one that was in conflict with the provisions of the withdrawal agreement and the.
Sorry, in conflict
with the withdrawal agreement and the withdrawal act, because you would be arriving at a position where you say, well, there's no other way to interpret these regulations other than by saying gateway provision means that there's just no jurisdiction, and because that is in conflict, because that is the argument being raised on appeal, my position would be that the court has to go further and say, no, the regulations continue to apply to UK-based central management EWCs, because that's the point of appeal. I use, at the risk of, well, it's definitely the case that this this appeals about jurisdiction. It's always been about jurisdiction. Yeah. But the argument depends upon a reading of the regulation as a whole. It doesn't depend on a bespoke amendment to the jurisdiction clauses, the jurisdiction paragraphs of the regulation. So I think the court does have to go further than just saying, well, UK EWCs can't continue to operate, but there is jurisdiction to consider complaints nonetheless, because that just wouldn't be compatible with the two conclusions were being consistent. Put it that way.
Good. Any questions? Thank you very much, Mr. Stilletts. Back to you.
Thank you very much, Lord. I think 4 or 5 points in reply, which I hope won't detain the court for too long. The first is to return to regulations 4 and 5 and what my learned friend said about those. So we're in tab 19.
Yes.
Page 357. Now, as I understood my learned friend's submission, he seems to be saying that pre-amendment, he accepts that this that regulation 4.1, regulation 5, determine the applicability of the regulations, but that post-amendment they do not. In my submission, that simply can't be right. The effect of the amendment in relation to 4.1 is simply to disapply 4.1 insofar as it refers to regulations 7 to 16. Those being the regulations in relation to setting up new European Works Councils. So they're out of the picture, subject to the limited provisions of Regulation 4.2. But Regulation 4.1 remains just as definitional of the scope of the regulations, albeit in relation to a subset of them, i.e. Regulation 17 to 41. And in my submission, there can be no basis for suggesting that the character of the work Regulation 4.1 does has been changed simply by virtue of the fact that the parts of the regulation in scope are narrower. This is a jurisdictional provision about the reach of the regulations on any view. So that's the first point I make in relation to that. And allied to that, if that is indeed the case, and this Regulation 4.1 does define the scope of the regulations, in my submission, the respondents provided no rational explanation for the meaning of the words only where in accordance with Regulation 5, nor has the respondent provided any rational explanation for the repeal of Regulation 5.1a. And we submit that on the language, leaving aside for present purposes the implications of this, it is absolutely clear that Regulation 4.1 limits the scope of the applicability of the regulations to where, in accordance with Regulation 5, central management is situated in the United Kingdom. And it's equally clear that the amendments to Regulation 5 have taken out of the scope of its scope a situation where central management is in fact in the United Kingdom. And in my submission, the respondents' arguments simply haven't grappled with the black letter of the statutory language. Interestingly, I read over lunchtime the Secretary of State's submissions to see what they said about the words only where in accordance with Regulation 5. They say nothing about that. And I also looked to see if they had an explanation for the deletion of the words in Regulation 5.1a. None at all. So they take it no further in my submission. just as on a point of process, as I understand it, the Secretary of State was given permission to intervene in the EAT, but then actually decided not to pursue the intervention at all. And so, although those submissions were before the EAT, there was an active decision not to participate further in the proceedings, although
Yes.
we can't speculate as to why. So that's the first point. The second point relates to the transitional provisions. And I preface that with saying that the transitional provisions can provide only limited assistance as to the core jurisdictional issue with which we're concerned, for obvious reasons. But I'm afraid I have to submit to the court that they are, again, highly anomalous. And if I could illustrate that by reference to two of them, they're in the amending regulations, which are at tab 23. I could invite the court to go there. Now, my learned friend referred to paragraph 34 at page 471, which on its face has the effect in relation to a request for information made under Regulation 7.1 before exit day, the effect of preserving that application. Now, if one turns to Regulation 7, that's in tab 19 at page 360. What Regulation 7 is concerned with is essentially the first preliminary step which might be taken by an employee if they were interested in establishing a European Works Council. And it is concerned solely with the provision of information on the basis of which the employee might subsequently make an application or put in train the process for making an application for the establishment of the European Works Council. That being the case, one immediately sees the futility of paragraph 34. Because even if it were the case that a request for information had been put in say, December before exit day, and the effect of 34 is that that information request should be complied with within 28 days, that's of no assistance whatsoever to the employee post-exit day, because it's common ground that one can't commence the process for establishing a European Works Council in the United Kingdom after exit. So it's on the face of it a provision of no ultimate utility, and it's to be contrasted, for example, with paragraph 41 in tab 23, page 474. Paragraph 41 says, despite the amendments and revocations made by Part 1 of this schedule, the 1999 regulations continue on and after exit day to have effect in relation to any complaint or application presented under those regulations before exit day to the Central Arbitration Committee or the Employment Appeal Tribunal, as they had effect immediately before that day. Now that, on its face, indicates that applications are preserved where they've been put in before exit day, but not otherwise. And in my submission, if one's looking for, as it were, the runes in the transitional provisions, that is very much supportive of the appellant's case in indicating that that's the cut-off. And in our submission, it's also the answer to the Article 127 point, in that that provides a remedy for any application made before exit day. So that's...
What do you say about regulations 35 and 36?
Well, again, they are likely to be similarly futile in that unless the European Works Council is established prior to exit day, provisions relating to further stages in the process aren't going to be in practice unless it's a very swift process of any assistance. But again, I'm afraid I have to make the submission that looking at 34, looking at 41, looking at these, this is once again legislation made in haste, which on my learned friend's case doesn't make any coherent sense. And in any event, to interpret the jurisdictional provision on the basis of transitional provisions would, in my submission, be tail wagging the dog, particularly in these circumstances. The third submission I wanted to make was that my learned friend suggested that the appellant suggesting, well, these regulations were made in error, and he's not suggesting that they're made in error. First of all, we don't say they were made in error. Our submission is that they were made in a manner which probably wasn't fully thought through in the way one would normally expect. But we have this curious position that the anomalies and difficulties that I've identified, for example, as to when the deeming provisions might apply, all of those apply equally to my learned friend's interpretation. So if he's right, the very limited circumstances where the deeming provisions would apply equally on his interpretation. The difference is that in the respondent's case, there is an additional and very real and indeed inevitable anomaly and difficulty with the regulations, which is only on his interpretation does one arrive at the wholly unworkable position of there being an obligation to have two European Works Councils operating in parallel, sometimes in conflict, sometimes putting individuals in difficulty as to confidentiality, and in practical terms, meaning that slightly different negotiations have to be undertaken with slightly different groups of people at slightly different times in different parts of the world. And that, we say, is a nonsense. So when my learned friend seeks to sort of suggest there's a kind of parity of anomalies in this case, in our submission there's nothing of the sort. On the one hand, you have the appellant's position, which is that these regulations haven't fully been thought through in terms of how they'll actually work out in practice and may have limited application post-exit day. But that creates no practical difficulties on a day-to-day basis in terms of the continuing operation of European Works Councils, and indeed has the result that in practice pan-European employers based in the UK or in third countries will do what EasyJet does and set up a European Works Council in a member state. On the respondent's case, you have the anomalies and difficulties and limitations which we've identified, but in addition, the inevitable and egregious practical problems that we've identified. And so, in my submission, this isn't the case where one can say, well, one just takes those anomalies out of the equation because they sort of cancel each other out. That's not the case by any manner of means at all. And so in our submission, that does weigh heavily, but ultimately one goes back to the jurisdictional, definitional regulations, starts with them, and we say the wording there really provides the answer. Unless I can assist you further, those are our submissions.
Thank you all very much. Mr. Stillitz and Mr. McCombie for your oral submissions. Ms. Belgrave and backup teams for the backup, which was excellent. We will, of course, reserve judgment. We'll send out a draft. I'm quite required to tell you in every case what council already know. Firstly, that the draft is sent out not for re-arguing the case, but for correction of typos and factual mistakes and the like. Secondly, that the draft is sent out subject to the restrictions on publication of its contents set out by the Master of the Rolls in the Counsel General for Wales case. But you know all that. Thank you all very much for your assistance.
Right.